Hi, Namaste, Namaskaram, Vanakkam. So today we are going to discuss about the right to privacy. It is written by the Aishwarya Gridhar and Nitishin. This right to privacy is the right. It's a fundamental right. The verdict given by the under the case Puttaswamy case versus Union of India by the Supreme Court. It's since 6 years of verdict. The Supreme Court gave a lot of rights regarding the right to privacy through the Puttaswamy cases. Some High Court also expanded the right to privacy to the people through the through clarifying about Puttaswamy cases. That is what we are going to see, and also we are going to see about the what are the opposite side of right to privacy, which is also the judgment which is given by the some court like High Court and Supreme Court also gave some verdict which is against to right to privacy in some verdict. So we can conclude that no rights is absolute, and all the rights are having plus or minus and everything, so that so limitation is that, so no right is absolute. That is what we should learn from this act and also from the discussion. So let's discuss. Okay, first, what is right to privacy? We know everything what is about right to privacy. Right to privacy is the personal right. It should not be published by others. It should not be published without the consent of the people. Without the consent of the people. That is what called right to privacy. And recently, Digital Personal Data Protection Act was passed. Through this act, the right to privacy in the online sector was ensured. That is what the discussion all about. And after this article discussion, we are also going to discuss about the what is that Digital Personal Data Protection Act also. So let's go for first case, Puttaswamy case. Okay, case Puttaswamy case gave the right integral. It gave the verdict to the integral. The fundamental rights is the integral part of the constitutions. So that is an important and landmark judgment. And also the court construed privacy not as a narrow right. It's not a narrow right against physical invasion, but is not only it's a physical invasion of the right to privacy is not only about the physical invasion. It includes the body and mind and enable us to make free decisions, and is deeply tied to human dignity and autonomy. And it's tied to human dignity and autonomy, because if you lose your privacy, then you cannot live with your dignity. If your health information, your reproductive health information and everything going in the public means the social norm gets affected, and it will be more stressful for that people who information is in the public. That is what's the biggest problem. Like the privacy enable us to be to make a meaningful choices. For example, the sexual and reproductive health choices of partners, and also and control over personal information. The personal information regarding sexual relationship and reproductive health can be the meaningful choices, and choosing a meaningful partner can be the best option through the right to privacy. And also and also through this judgment, there is judgment through this Puttaswamy case. There is judgment came on other cases also, which gave the right to privacy to the it extended the right to privacy to some other sectors. Like we know about the adultery was decriminalized in India, so that they can choose anything and not involving in the family matter. That is the privacy of their own family. So that is also an important judgment which is gave. And also the can do the adult can do any sex with any persons without with the consent of the person. That is not a criminalized. And also the same sex also they can do. This is also criminalized. This is also their own privacy. They should not be involved by the government or anyone. And also they are talking about the right to marry across any religious and caste lines. That is also autonomy and self-recognition. It is also given by the same judgments. So and also it talk about the end of life care, and reaffirm the right to die with dignity. They gave the Estonia like a end of life care. So if you are living in coma stage for a long time, means you should they should not live like that. It is affect their dignity, so they want to die, so that we can end their life care, then they can die with their own dignity. This also this type of judgment also came in the Supreme Court. And also we can see the right to forgotten. Okay, right to forgotten is important judgment gave by the High Court. And forgotten means if you gave some information to the someone, and the information should be erased because it can be used to manipulate your future. So that should not be happen. So that's why the right to forgotten is also under the, we can call it as a right to privacy. And some cases privacy among the other ground has been also used the basis for the taking down the intimate images of individual where they shared without the consent. So some images of intimate relations with someone which is shared in the public places, it should also be erased. That is also become a right of the people. And clarify the limitation on the powers of investigative authorities in relation to surveillance, search and seizure, and DNA testings. However, the right to privacy has not always prevailed in the Supreme Court. So, we are now going to talk about what are the opposite judgment against the right to privacy, like Sabarimala cases. In Sabarimala cases, the women are allowed to Sabarimala temple. That is against the right to privacy of the temple culture, and also the hijab issue. Educational institution, in the educational institution, the woman should not allowed with the hijab. That is also the High Court gave judgment like this. That is also in the discussion under the Supreme Court is still waiting for the, we are waiting for the judgment what to come from the court. And also the Pegasus suit, the Pegasus, the government, it is Pegasus case also discussed about the involving government in the right of the people's privacy, and they are getting information of the people. That is also against the against the people's right to privacy. That is also discussed here. So right to privacy, and we have a lot of judgment done positive side also, and it extended the freedom of people, and also has some negative side. It also involved in the right to privacy, because we can say that, we can conclude here that whatever said in introduction, that no rights is absolute. All the right has limitations. That's what we can conclude here. Okay, so let's discuss about the what is the act saying. Okay, now we are going to discuss about the Digital Personal Data Protection Bill 2023. Now it became an act. So, what is the act and why we need it? We need this act. Like that, we are going to discuss. Let's see the first. The Lok Sabha allowed the introduction of this bill is announced recently, and both the parliaments both the parliament Sabha is accepted this long-awaited act. And what's the need for digital data protection bill to the. So after the Puttaswamy cases, lot of people are asked to protect our data in the public platform, like in Google or some other digital platform. And we have no act called, separate act called the Personal Data Protection Act. So only we have a Information Technology Act only, so that the people asked to do that. And also BN Sri Krishna committee also recommended to have a separate act for India. So that's why this act was framed. And we now going to key features of digital personal data protection bill 2023. Its applicability: the bill will apply to the processing of digital personal data within India. It will also it include within India those who are all taking information from India, and also using that information for processing in another country. Also, this act applicable to the all persons, those who are using the Indian informations. And it also applicable to the both public and private sector. So, and second, consent. So consent of the people, consent of the particular persons, those using of information should be needed. If the person is more than less than 18, then consent of the legal guardian should be get here. So that is what they are telling. And if the notice should be some the personal details, if the person from the personal informations, the person's information, if he or she asked to remove that information, that should also be considered. So the erasure option, also right to forgotten, also be mentioned in this article, in the act. the consent at may be withdrawn at any point in time. Rights and duties of data principles. And here we are going to we have to know about what is data principle and also data fiduciary. Data principle means the person who is having informations, that is called he is called a data principal, and data fiduciary means who is using this information is called data fiduciary. Like we can say that if I am a patient in some private hospital, the patient is called data principal because his information used by the hospital, and hospital is called data fiduciary, so because they are processing and using the informations of the data principal, that is called data principal and data fiduciary. Okay, so the what are the rights and duties of data principal? The individuals whose data is being processed, that is called data principal, and obtain information about processing, seeking correction and erasure of the personal data, and also they are giving correction and erasure of the personal data is also ensured here. And also they can nominate some other persons in case they are dead, or in case they cannot take decision, like incapable of delivering decisions. That time also they can nominate a person to for represent for the decision. Okay, next is the transfer of personal data outside India. The outside India can be done, but it is limited by the government. A government can authorize anyone to which country and which person to deliver the data. And here some of the exemptions also given in this act. So the government can use the exemptions, so government can notify the in any time to remove this kind of informations, this kind of for illegal purpose and public interest and security of the state and public order and research achieving statistical purpose, government can use the data. And also for the enforcement of legal rights or claims can also the government can use these data. So next to the data protection board of India, they are going to form a data protection board, but data protection board central government going to establish that, and it monitoring complaints and imposing penalties, directing data fiduciaries to take necessary steps in the event of data breach, hearing grievances made by the affected persons. And also it here the some of the grievances which is it is a board, and that's why it can ask any type of grievances from the people. And penalties, if the non-fulfillment of obligations of for children, it has 200 crore, and if it is breaches of or failure to take security measures, it's 250 crore. Okay, penalty. What is that significances, right? Significance means it gives the it ensures the right to privacy of case Buttaswamy case. And also it talks it's gave wider comprehensive analysis and take decision for safe and security data protections. And also it gave the hefty fine those who are not following the act. And this is important and valued more that data is more safeguarded than before. While comparing with without act, the act is better. That is what they are trying to say. The digital personal data protection bill 2023. What are the concerns? The here wide range of exemptions given by the government. So the government is can exempt at any time in the name of public interest. It is very very considerable. And also dilution of powers of the data protection board, an amendment of the right to information act 2005, that is also be considered. RT act is amended because of the personal information. So under this the personal information should be protected, so that the right to information is not come under right to information cannot be given in the name of in the event of right to protect right to privacy under the personal data protections. And also the 43 of the IT Act 2000, which requires the companies which mishandle users data to compensate users. So the compensation provisions which is given under the section 43 of IT Act, which is now there is no such kind of provisions in this act, because because they are calling that the putting compensations, it's a judiciary, it's not an executive thing, so that judiciary will decide what to do, what not to do, like that they are taking. What are the other countries regulator data privacy? Now if you consider the data privacy of other country like European Union's general data protection regulation, it's an important thing, GDPR, and it is the toughest privacy and security law in the world. And China, Vietnam, Australia, everyone having their own law. That is what here they are saying. Okay, so it expanded the article 21 to the all. That is what the conclusions, and it gives them more better visibility, awareness, and decision autonomy and control over that data. It is the first step towards protecting the privacy of the people under the case Puttaswamy case. So that is what we are discussed here. Thank you, and we will discuss next topic tomorrow. Thank you. Bye.